Go in together live.
Conduct and responsibility to apply to all of us in this courtroom. I'm happy to send the jury home for the rest of the day, and we can go through all of them, including the administrative order, which adopts all of them in this circuit. I hope that that's not necessary, but if that is necessary, I'm happy to do it. What brings us to this situation is the argument that ensued about the refreshing of recollection, which is something that is essentially taught in the first year of law school, and debating over the semantics of it, and then sniping at each other and talking over each other, which is just going to end. It's not going to happen anymore, okay? Because if it continues, I'll simply declare a mistrial. That's what I'm going to do. That's my warning that we all need to be professional. We all need to be careful. Okay, it came up that perhaps the jury can hear what I'm saying from over here because I talk loud sometimes. I'm not yelling, but I do talk loud. And I don't know that that white noise is sufficient. In fact, I'm told that if defense counsel can hear it, that perhaps the jury can hear the discussions at the bench. So there's a fix for that too. We can send the jury out every time there's a need to approach, and we'll eliminate any possibility of the jury overhearing what we're discussing at the bench. What also adds to the problem is the number of people that approach the bench who some may be talking to me, some may be talking to each other, some may be talking to other people, and it creates a problem. So, also pursuant to the administrative order, I have the ability to impose additional rules in the courtroom that may address responsibility and professionalism of attorneys. And so I am going to announce a rule that we are going to follow from this point forward. Only one representative from each side will be permitted to approach the bench. If that person requests an opportunity to go back to the table to discuss with someone else, I will allow it. But we're only going to have one person at the bench at a time from this point forward. Now, we're going to go back to the witness that was on the stand and the refreshing of recollection, and I am going to allow the state to identify whatever the object is. That was his question. That's what brought us to this. He asked, when the state asked whether his recollection was refreshed, whether that was a transcript of the recording. And I'm going to ask you all first to tell me if you agree that it is or it is not. That's something very simple that the attorneys outside the presence of the jury can make a determination on. It either is or it isn't. So I'll start with Ms. Hodges. Ms. Hodges, is what you were using to refresh the witness's recollection a recording or a transcript of his recorded interview?
It is, Judge. At the top, it's titled Transcribed Interview with the date of October 8, 2012. The location, interview of, and then who conducted the interview. And then it has line by line the interview. And
I understand that, but despite that, there's some confusion because there was two interviews that appear to have been made simultaneously, and it's created some confusion. The defense brought that out on cross. I think the witness was confused as well, whether that's something that the detective wrote up after he talked to him and then recorded him. It appears, and you all may know better than me and correct me if I'm wrong, that the detective talked to him, asked him some questions, and then said, okay, I'm going to interview you, I'm going to record you, and then re-interviewed him and recorded him, basically the same, I don't know, I wasn't there, but essentially about the same incident, and now it was being recorded. So now there's this air of confusion as to whether that is in fact the statement that was made while being recorded, or it's the statement he made right before he was recorded and was somehow written down or somehow recreated by the detective. It sounds like, and I'll give the defense an opportunity to agree or disagree, because I'm sure you got a copy of the recording, an audio of the recording, and then can look at the transcript and agree or disagree as to whether that item that they've used is in fact a transcript of the recording. So I'll turn to the defense. What's your position? Is that the transcript?
All right, and here's what we have to do, folks. We have to hit the pause button. You're going to hear the defense response in just a couple of seconds. We're going to unpack what we just saw here, the new rule from the Honorable Christopher Sabella, taking control of the courtroom and the situation. Apparently, it was fighting between the attorneys. That's what was going on, folks. Stand by. We'll be right back.